And good afternoon. My name is Margaret Petros. I'm the Executive Director of Mothers Against Murder, MAM for short. It's a victim advocacy nonprofit located in the Bay Area. I am a longtime victim advocate who has helped families across California impacted by homicide, rape, domestic violence, child abuse, and other violent crimes. I'm here today to respond to the proposed California victim compensation regulatory changes. I did submit formal written comments weeks ago, but it does not look like any of the recommendations were considered because what I see today in draft is the same as the one that was open for comments in April. So I'd like to begin with a fact that cannot be ignored. This regulation is being revised directly because of the court decision in Mothers Against Murder versus California Victim Compensation. We were the plaintiff. I led that case. I am the reason this is happening today. So when I speak to these regulations, I do not just speak as an advocate, but as the person who forced California victim compensation to correct its course. And for my written comments not to be acknowledged in any one way, shape, or form, not even an email back saying you received it, it's disappointing. These regulatory revisions are not just technical. They redefine how victims are treated during the most difficult time of their lives. These revisions were prompted by an order of Judge Frank Rouge. So once again, I see California victim compensation twisting some things that should be corrected. And this taken as an opportunity to really correct some harmful practices. First, I do want to touch on hearing officers. And in the past decade, California victim compensation has shifted toward using lawyers as hearing officers. I think this has fundamentally changed the tone and the intent of the hearings. There are no longer victim-friendly staff that can just sit and get the truth out on the side of the victim. It's more adversarial and intimidating. I will never forget the first California victim compensation hearing officer when the hearing officer were placed in the statute to take some offload from the board members. I don't remember his name, but he was a Black gentleman who was so compassionate, approachable, respectful. He sat down with victims. He listened to both the victim and the advocate, when I remember that. And he did not interrogate. He was not a lawyer. He was fair, and most of the cases that were recommended for denial were overturned by his recommendation. Contrast that with the recent experiences. It's been really difficult to face a hearing officer that is a lawyer who is set on proving the staff facts, and it's very intimidating. So I can only imagine if the victims are doing this all on their own without an experienced advocate. I want to use this public hearing as a plea for the board members, for staff, for the governor, for the attorney general to listen and not to use lawyers as hearing officers. It's become a toxic culture. And it's just extremely difficult, and that's not what this program is about. I also want to address transparency and equity. You're clarifying the Penal Code 4900. Applicants who were wrongfully convicted have the right to attend the meeting where the board members deliberates. It's great. I am asking for the same for crime victims. If they wish, if that's their choice and they make the request, when the proposed decisions of the hearing officers are being heard, crime victims should be notified and allowed to present their case to the board members directly, whether it's at the public hearing or in the closed session. Please consider that. And now I want to talk a bit about the regulations themselves. Section 617.4, hearing by electronic means. I would like to see the in-person hearing clearly defined. When it's separated under section A and C, I'm afraid it will become confusing as the years go by, and based on my experience with CA VCB staff, I'm afraid that section A, if read independent of C, the hearing officer will have the option of holding the hearing by telephone. So you can combine that to make it very clear that if the applicant chooses to have an in-person, that in-person must be given. Section 617.7, presentation of oral evidence. When you require a traumatized victim to testify under oath at an informal hearing, it is intimidating. And I believe it is inconsistent with Government Code Section 13959E1 that requires the informal hearing. And the intention, I believe, of the legislator, it was written to protect victims from burdensome legal formalities. Traumatized victims should be treated as such, with trauma informed, and allowed to speak freely, not be intimidated under oaths. Section 617.9, I'm asking that you do not assume that failure to appear means withdrawal, and that's how it's written now. Applicant does not appear, it's automatically withdrawal. That is cruel interpretation when dealing with people suffering extreme grief and post-traumatic stress disorder. Most of our clients, mothers of murdered victims, oftentimes cannot get out of bed. There need to be understanding and willingness to work with traumatized survivors, allow them to explain why they were not able to be at the hearing, and allow some flexibility, please. Section 619.4 and 619.5, the proposed decision should be sent to both the applicant and their authorized representative. Now it's either or, it's confusing. I know from my experience, it's very difficult for applicants to understand the letters they receive. And oftentimes they don't even communicate with their authorized representative. It's the right thing to do. It's common practice in all the other government agencies and benefits. Both are notified. It's not too much to ask for. It's a very important meeting, and the representative as well as the victim should be notified. So not one or the other. Section 647.20 C, it's the provision this is very important for me because it's an attempt, I think, to subvert the decision of MAM versus CA VCB, requiring victims to request a hearing again after they have already contested a denial is not only confusing, it is harmful. It leads victims to believe their case is over when it isn't. The result, they give up. We know they give up. Right now, when you were doing the no hearing letters that was struck down by the court, you asked victims to respond. And in what I've tracked, in about 90% of these cases, victims do not respond. You must think about it. Why, after they've already asked for a hearing, they're not responding back? They just give up, and we don't want them to do that. So you need to work with them and also follow the law. It says, if a victim contests a denial, you shall give them a hearing. Why, again, they ask for a hearing, and then it gets to the hearing officer who will write the proposed decision, send it to the victim, and it says they must ask for a hearing again to schedule a hearing. That's not okay. And that's, I think, exactly what CA VCB wants, is for victims to give up. But it's not what the law allows. Once a denial is contested, you must automatically set a hearing that was made crystal clear by the court. This regulation contradicts that mandate and must be struck. Section 647.22C defines good cause for rescheduling a hearing. Leaving the good cause as is to interpretation, I'm afraid the discretion invites arbitrary and harmful decisions. So please define what good causes are for rescheduling. Section 649, the date of application should be the date it is filed with either CA VCB, or if it goes through the local victim assistance offices in different counties. My understanding here, if they wait and it's the day they submit it to Sacramento headquarters, that it's considered the date of application received. It shouldn't be. The local office, if they sit on it for months, then it's a problem. So the requirement should be both. If it's received at the headquarters or at the local office, that's the date used for receiving the application. Section 649.8, it's also something that's very troublesome for me. When you say emergency applications can be changed to a standard application, it's not okay. It should not. The emergency law for that processing is very clear, and you must make a decision on it within 30 days. Quietly downgrading the emergency application to a standard application, it's not okay. So please make sure that are separated and follow the law on this. Emergency is different from the regular application, and that's how it should be. Thank you so much for allowing me to take more time than you initially said. I really appreciate it, and I appreciate your efforts and your time. Thank you. Okay.
Right.
I did not write on this, and I've been thinking about it. Under Section 615.2, the definitions of informal hearing, specifically Section 8B, that restricts cross-examination, I believe some level of cross-examination by the applicant and or their representative is necessary. Government Code Section 13959E requires informal hearings to protect victims from having to hire an attorney or have to understand the rules of court when presenting evidence in formal hearing. The intention is to help victims, not restrict them from effectively challenging the state's version of events. By saying informal equals to no cross-examination, I think it silences the victim when evidence is wrong or incomplete, or even when it's misinterpreted by staff. I think the worst of all this is, in my experience, when victims or families of murdered victims cannot get a copy of records that you used to deny the claim, specifically crime reports. You do not release those to victims when you actually use them, use that information to deny the claim. In murder cases, police reports are not released to the victim. Victim is deceased. So that due process is not there, especially when these families have the burden of proof. It's very difficult for them and for me as an advocate to stand up for them if we don't even know what the information is in law enforcement records that you get. I do not believe the law restricts you to. This is what I've heard from your lawyers. I believe if it's a minor, you cannot release it or other confidential information. But again, in homicide cases that mostly I work with, law enforcement complete a one-page form. It's 3 questions. In what way releasing that jeopardizes law enforcement investigation? So that's another very important area where, while you're looking at this closely, is to allow for the victims to have their information. It's their file, it's their records. It is baffling that they don't get everything that's in their record, that especially when used to deny the claim. So again, some level of cross-examination or having the staff that made that decision available at the hearing to answer questions would be very helpful. Thank you.